We had one guy recently who actually was an attendee here and at the library who was fired from a really big company, off for a number of months, and then was offered a really good job at a competitor. And the competitor said, as they should, do you have a non-compete in your deal from the old company? Now, mind you, does it matter that the person was fired rather than they left voluntarily as to whether the non-compete is enforceable? No. You say yes?
I would think so.
I'm so glad you're here. I'm really, thank you. You got to know, the contract will say, this non-compete survives your employment, period. So this guy's stuck. He wants the great job, but he's pulled back by the other job. So what do we do? There's a term, yeah. You're going to sit out for 2 years.
That's a long time. Yeah.
You know, it is, but it's enforceable.
For 2 years?
Yeah. The answer is no. It doesn't, it can be foolish, unreasonable, as long as it's not unconscionable. There's an unconscionable deal. Here's an example. Do you know that in a bunch of states, all the McDonald's, French fry, and burger flippers were offered and mandated to sign non-compete agreements? What does that mean? That's insane. So if I had one of those, I had one. A masseuse was told within 5 miles of where you were, you can't massage anyone, and you can't take your customers and this and that. And the lunatic, this was called, I'm going to say it, massage envy, okay? Apparently there is such a thing. I think it's Freudian. But the point is, massage envy told this woman who was a single mother raising her kid without help from anyone, you can't work at the competition over there where you got a job with 3 times the pay because you signed this stupid thing on day 3 of your employment there. So, and he had a lawyer for this. So I write to the lawyer writes me and says, as if this is like IBM, major litigation. He says, we want you to retain the following documents, which have the following words. Do not dispose of them, because we will sue you for spoliation of evidence. And I said, that's fine. With my client's help, I said, we want the following on the manager who fired her. All information that he was serving alcohol to customers, that he was putting his hands on them without a license, that he was smoking pot on premises, and a bunch of other things. And do you know we never heard from them again? Case over. They will normally say, don't solicit our employees, don't take our customers, you're going to get a gamut. By the way, the big company that rewrote its non-compete with the guy, with the 6 or 7 customers, that document was 15 pages long. They will go crazy to document and figure out sometimes. So, non-solicitation, non-competition, confidentiality agreements, we pretty much said that. If it's confidentiality about discrimination claims, it's void in the private sector. Non-compete agreements under the new statute, they're not making law, they're just reciting existing law. Non-competes will be enforced if they're reasonable. Now, mom and pop store at the corner of, First and Jefferson says to Julio, you're here on your first day of work, please sign this non-compete. The geographic region is the world. And 10 years. Okay. It's an extreme example. It's unconscionable. It's unfair. Oh, and I need to say, New Jersey does not like non-competes as a matter of public policy. It considers them anti-competitive, which they are. So what they're saying is, we'll do it kind of like a sniff of a bad smell. We'll do it disdainfully. So you better get it right, employer. Reasonable in time and geography. Now, if you're working for IBM, worldwide is probably right. But 10 years is not. You're never going to see one that's enforced at that level. And judges are permitted at the first level. They have what they call the purple pencil. Does anybody remember pencils? Okay. They can strike through the stuff that to make it, and they can cure it. If this is a problem, this is the part that will be enforced. Now, it's very expensive. The best ones, like the masseuse lady, she didn't have the money. Here's what I said. They put a 5-mile restriction. Why don't you do massage 6 miles away? Just, make it simple. But the idiot employer went and sent a nasty threatening letter to the new employer. That happens all the time. That's why the big company that was going to get the other big company said, fix it there. We do not wish to be sued. We also don't want to be sued as who? The recruiter, because these are all interference with contractual rights of the previous employer. So when you're asked, did you have a non-compete? What's the right answer?
You have to say it.
Anybody say, none of your damn business? Anybody? Be proud, it could be right. No takers. Okay, don't do that. You gotta tell them, even if you're unhappy to tell them. Now what this employer did, the massage place, they actually joined the case. They said, we will pay for her legal fees. And I'm like, yippee, because now we can proceed. That's not a contingent fee, people. That's like, there is no pot at the end of that rainbow for her, even in a cannabis state. The answer is you don't go to any employer with that problem. You fix it before you get there best you can, including talking to the previous employer. Matter of fact, what I do when I have one of these and there is a severe burden and it's a highly compensated employee, I will say, let's put into the severance deal the right for you to contact the employer, specific office, if you can do it, specific person. So when the job comes up, you can go to them and say, what about this one? And if they're in good faith, they may not care. So you have to set up a system that will get you to the right answer the quickest way you can. If you can't do it, stop feeling sorry for yourself, go to the next one and keep going. Same thing. It's exactly the same thing. If I did not make that clear, coming in, going out. Sometimes what happens, this is interesting, sometimes employer dimwit says, we got a lot of employees here and we got some intellectual property issues and protectable interests. They're already working. We didn't offer it to them at the time they came in. They're not leaving. Why don't we have a mid-employment non-compete? Probably not enforceable. Unless they say, here's $25,000. Want to sign?
That's what they did to me.
No. What happened?
I took it.
Which is what I would have told you to do. I was like, dude, can you do without $25,000 today? Alex has the question.
I don't know, but assume you work for an employer, and the employer after X years says, oh, by the way, I would like you Monday to sign a non-compete.
This is what we're talking about right here. That's what happened to him. The answer is, what are you paying me? Because without it, it's not enforceable.
Well, he says, I don't pay you anything. You work for me, I want you to sign.
Then fire me, and I will collect my unemployments and bash you to death.
Off a job.
Okay, I'm sorry. You heard what the guy said. Go into real estate. Sell furniture. There could be a legitimate employer interest in asking you to sign something because something new happened that changes your ability to hurt them in the marketplace. And I'm going to say the answer is you can do it, but you ought to ask them for something because they've just asked you for something. That could be worth a lot. Now, I don't want you to think of today, tomorrow. I want you to think you signed that thing 5 years, 10 years, and all of a sudden, that's the job, and you signed off. What did they pay you for that? These are two excellent questions. One, why is 2 years a reasonable time? And two, how do we define competition? Normally, the the employers are the ones who proffer these documents. And the counsel for employee, which they always tell you, get a lawyer, by the way, and you always should, right? Even if it seems straightforward, sometimes you may not be seeing everything, and it doesn't cost a lot of money to get that reviewed. So competition is normally going to be defined, but it may not be defined well enough for you. So that's what we'll do. Tell me, what's competition to you that we can go back and, tweak this document? The 2 years is like custom. You're not going to normally see one that's longer unless it's a highly sensitive, position, and there have to be really, really good reasons built in for that, ordinarily. So vesting is very tricky, because let me tell you, sometimes in big companies, that's normally who offers them, if you are cut off at a point, those stock go away. I've had people say to me, that's $700,000 out of my pocket. Can they just carry me 9 more months? I'm like, I'll ask, but they know the math the way that you do. If it's not illegal, you're sorry. You just go build it elsewhere. And what was your second question?
Was about certification.
Oh, I'm going to say certification that you have not been in competition. I've never heard of it. I don't think it's illegal or unlawful. It's like saying, I remain a loyal, steadfast employee. I've done nothing wrong. Signed, Billy Bob. It's okay. I've never heard of it, but I don't find it sort of instantly offensive to the brain. All right, let's keep going.